Turn to M3 and Karen B for this week's episode of Comply on the Fly. You'll get quick and timely answers to the most common employee benefits compliance questions so you and your business can keep moving ahead. Please note this podcast and the contents herein do not constitute legal advice. Please seek the advice of counsel for any benefit compliance-related implementation, guidance, or strategy.
Hello, everyone. I'm Karen B. And the Comply on the Fly question of the week is, I've never heard of the COBRA Notice of Unavailability. Can you tell me what this is? Well, absolutely I can. In fact, I'd love to, because when I discuss this required notice with clients, I typically get blank looks. Most often, I get the response that they've never heard of this notice before. And I always respond, that may be, but it is a required notice and is included on the document request for DOL audits. So, what is it? It is a notice that informs certain individuals that although an event may have occurred, COBRA is not available in the situation. Typically, it is for situations in which you determine an individual is not entitled to COBRA. More specifically, the regulations say it is required to, quote, be provided when a plan administrator denies continuation coverage because it has been determined that no qualifying event had occurred or because the qualified beneficiary did not furnish the qualifying event notice in a timely manner or did not provide complete information, end quote. So, the notice is required in the following situations where the plan administrator receives one of the following notices: a notice that a qualifying event has occurred, a notice that a second qualifying event has occurred, or a notice that an individual has been determined by the Social Security Administration to be disabled, and the administrator determines that the individual is not entitled to COBRA or an extension of COBRA in that situation. The notice should be provided to the person who was expecting to receive the COBRA coverage. The best examples would be a late notice of a divorce or a termination for gross misconduct. In the divorce situation, if the notice is provided after the 60-day notification timeframe, COBRA would not be available. So instead of sending the COBRA paperwork, the notice of unavailability would be provided. Of course, this would be predicated on the fact that the employer can prove that the initial notice of COBRA was provided, because this is the notice that actually tells people they only have 60 days to notify you in case of divorce. In the termination situation, COBRA is not required if the termination is for gross misconduct. Instead of COBRA election paperwork, the notice of unavailability would be provided. Although caution, if you do terminate someone for gross misconduct, we suggest that you work with your own legal counsel to determine if an offer of COBRA should be made. If you outsource COBRA administration, please note that most COBRA third-party administrators or TPAs do not provide administration of this notice, and it will be up to you to provide it. If you don't have a copy of this notice, please contact your M3 account team. And that is your Comply on the Fly question of the week. Thanks for tuning in.
What's on your mind? If you have a pressing compliance question, send it to askkarenb@m3ins.com. We'll do our best to cover it in an upcoming episode. You can now follow and subscribe to Comply on the Fly on Spotify, iTunes, and Google Podcasts. Make sure to tune in next week and encourage others to join us.